This is Attorney Sharp Raleigh, and we are going to discuss about the difference between period of stay authorized by the Attorney General versus the unlawful presence, or what are the distinction between the two. Oftentimes people will confuse that, and it will create many problems in their applications. Whenever someone enters the United States, they get something called an I-94. Usually this is what, if you're a non-immigrant, most of the non-immigrant visa will get that. Either you are on B1, B2, F1, or even H1, H2B, etc., etc. They get an I-94. That I-94 controls your time. However, in order for you to extend that I-94 or even change status to another non-immigrant visa, you have to be in status. What it means is it has to be filed timely before the original I-94 expires. And many times people will be confused because once it's filed, you are actually allowed to stay in the United States while it's pending, as long as it was what we call timely file. Timely file means it was filed before your I-94 expires. Now, what happens if you file something and let's say it expire, and your original I-94 is expired, but you have a period of stay? That means an extension or a change of status was filed for you, but in between that, while it's pending, you want to change to another status. For example, let's say you came on a B1, B2, you wanted to extend the B1, B2 expired in June, and you file a timely extension which is before June, and it's pending, and after around, while it's pending around July, you get an offer under L1 or H1B visa, and you want to file for a change of status. Can you do that? Well, you can file for the H1, but you cannot file for the change of status because technically you are not in status. You can only do what we call consular processing. However, if the B1, B2 extension is approved and then you file for the change of status, that is allowed. But as long as it's pending, you are allowed to stay. This is what's called the non-unlawful presence. That means you are not accruing unlawful presence, also known as period of stay authorized by the Attorney General, that you are allowed to stay. But what you are not allowed to do, you are not allowed to kind of piggy ride on that pending status to file for another change of status or an extension in a different category, or even in the same category, as a matter of fact. So be very, very careful. There is a concept which many lawyers have claimed, and there's a memo on this that was issued in 2003 explaining that, where a bunch of lawyers mentioned the fact that if it is pending, you should be able to change status. But logically, it's not doable, because the word change of status or extension of status means you have a status. But while your case is pending, what you have is not a status. What you have is actually a period of stay authorized by the Attorney General, which is not a concrete status. And as such, it's very clear from this memo and from other memos they have made that you will not be able to to make a bridge. This is what everybody talks about all the time, the bridge. However, there is an exception. It's at the discretion of the USCIS. We have seen many times where USCIS will allow this, but it's not a matter of law. It's a matter of discretionary power, and it clearly says in the regulations, if you look at it, and I think it's on here, they mention it also, it's at their discretion. Here it is. So INS, which is the regular back in the days before Homeland Security, a CFR 248.1 state a change of status may not be approved for an alien who failed to maintain the previously accorded status, or whose status has expired before the application or the petition was filed, except that failure to file before the previously authorized status expired may be excused in the discretion of the service. Emphasis added. So what it means in simple terms, they might allow you to do that only in exceptional circumstances. I've seen it being done in few cases, but it's not something which is automatic. So Be ready in a case where you have a pending change of status and you're trying to move to another status or do extension on another kind of non-immigrant visa, that you might have to do consular processing. This problem arises a lot when people are transferring H-1B. If the transfer is not done on time, before your employer cancel your H-1B, or if you don't have check stub, and this is where they might ask you to do consular processing. Now, the question today was about period of stay authorized by the Attorney General and unlawful presence, and unfortunately, it's so tricky if you don't understand the intricacies of those laws to really assess a case. So we recommend that you give us a call at 510-742-5887 if you have any questions. And anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Feel free to call us 510-742-5887. Please comment and subscribe until I come back with another video.